Very much. So, Eoin is, as John mentioned earlier on, a senior lecturer in TCD as well as a barrister. So, Eoin's going to give us an overview in terms of international standards, have a look at some of the case law that has transpired out of having our FOI legislation over the past few years, and then give us some ideas on what kind of reforms might be envisaged in the upcoming time. So, Eoin, I'll hand over to you.
Thanks very much. I really should have been sitting in the middle here if I'm both your gatekeeper and mediator. My interests are more general than freedom of information. They're freedom of expression, media, online matters, that sort of thing. Freedom of information is just one aspect of them. And I thought I would today talk about a couple of important issues relating to the application of the legislation and the issues that David has just mentioned. And I would do it in a kind of a hypothetical. And I'm reluctant to go too deeply into the details of the hypothetical in case either Gavin or Sean kicks me under the table and says, well, actually, that's not how it will happen. So please join me in the hypothetical and hopefully they'll fill in the blanks in what I want to say. The hypothetical that I want to talk about is the nationalised or proto-nationalised banks, the extent to which freedom of information does or doesn't apply to those banks which the government now has a majority share in, or those regulators or other agencies that have been dealing with the fallout to the financial crisis in the last 2 years. It being, I think, a topical issue, and it being one which I think will illustrate a lot of the points that Gavin and Sean have just made. First point is the application of the legislation, and the application of the legislation to the bodies that I have just mentioned. As Sean has said, the freedom of information legislation applies to public bodies. And the relevant list of public bodies is published on the Department of Finance website, much more accessibly, but Sean was too modest to say so, on the Information Commissioner's website. And these are bodies that are described either under the Acts or by virtue of regulations made by the ministers as public bodies for the purposes of the Act. Now, it's quite a broad set of bodies that are defined as public bodies for the purposes of the legislation. It started with government departments, and then it went on beyond that to most state agencies and bodies, various levels of local government, the HSE, the broadcasting sector, the third level sector, and so on. But there are, as Sean said, lots of public bodies that are not within the remit of the Freedom of Information Act yet. They haven't been actually effectively brought within it by the minister under the Act. And a lot of the, not just the commercial semi-state bodies, but also the kind of regulator bodies that have been looking at the financial crisis are not within the freedom of information at the moment. The central bank, the NTMA, NAMA, they're not, so far as I know, subject to what Sean might say, within the ambit of the Act. Now, importantly, the minister can make orders bringing things within the Act, but these have not yet been brought within the Act. But there are limits on the minister's powers. He can only specify public bodies. A body that's a private body cannot magically be transformed by the minister into a public body for the purposes of freedom of information legislation. We have a very interesting example of this, given that this is the time when I get busy because the students are back in college. Just before the summer, the Supreme Court told us that the Central Applications Office is not a public body for the purposes of the legislation because it is simply a creature of an agreement between the universities and hasn't been created by legislation, and it doesn't have any of the other things that go into making it a public body. There's an awful lot of lawyers' law as to what the difference between a public body and a private body is, but once that was applied, the Supreme Court said the CAO wasn't a public body for the purposes of the FOI legislation, and therefore the minister could not make an order bringing it within the legislation. While I'm talking about education, I'll just simply say that the universities and the institutes of technology that have been created and that are regulated by statute are within the ambit of FOI, but the large range of private colleges that have arisen in the last 10 years, 15 years or so are not within the ambit of the FOI because they are not public bodies. So I suppose the first question then is, are the banks public bodies for the purposes of the legislation? And the answer is no, they're not, because they are public limited companies or other kinds of companies, and they are private bodies. They aren't created by legislation, and they're not set up or, in some sense, exercising public functions. But this is where lawyers love the Freedom of Information Act, because big fleas have little fleas upon their backs to bite them, and little fleas have littler fleas, and so on ad infinitum. Legislation just keeps going like that down through the levels. And the Act makes the point that the minister can decide that a company, a majority of the shares in which are held by or on behalf of a minister of the government, can be made subject to the legislation. And we know that there are several banks which are wholly or majority owned by the government, and therefore the minister can make an order bringing them within the remit of the FOI legislation. No such order has been made, but one is possible, and perhaps there ought to be a little bit of a clamour, Gavin, to ensure that the minister does make such an order. Now, that's my first point, the application of the legislation. It could apply to banks wholly or partly owned by the state, but at present, it doesn't. Even when the legislation applies, what Sean and Gavin pointed out was that there's a whole series of exemptions. Even if a body can be made subject to an FOI request, there are all sorts of hoops that have to be jumped through, not just the €15, but also making it clear, asking for information that they have, and so on. And then you have to hope that one of the exemptions that the Act allows for do not or does not apply. Now, there are several exemptions in the legislation. Lots of specialist areas. Gavin mentioned the environment. Health is another, where there is a whole range of different additional exemptions. But in general, the Act provides for or to ensure that one of the exemptions, is that financial and economic interests of the state and public bodies are not published. So, even if the minister makes the banks or NAMA subject to FOI, one of the officials being asked for information might still say, oh, but that reflects the financial and economic interests of the state, and therefore we're not actually going to disclose the information that you were looking for at this time. But that's not the end of it, because there's another flea upon which we can bite the back of, and it is the point that Sean made, that most of these exemptions are themselves subject to an override of publication in the public interest. Even if a bank were to say, well, we can't tell you that because it's a financial matter in the interest of the state, you could say, but the public interest overrides it. Okay, so now we have the banks might be made subject to FOI by the minister if he wanted to. Then we have the possibility of exemptions, but then the possibility of the exemptions being overridden. That's not the end of the matter. If you're looking for information, there might be other ways in which the information cannot be or must not be released. So even if you have the possibility of making an FOI request, you might still run into the problem that the legislation setting up the public body itself takes chunks of that public body outside of the FOI. In fact, one of the there are less than 20 cases in the High Court, and only 3 of them went to the Supreme Court. And one of the 3 in the Supreme Court relates to a section in the Education Act, the year after the first FOI Act, which carved huge chunks of information relating to education out of, or sought to at any rate, carve huge chunks of education information out of the FOI Act. So it may be that legislation setting specific bodies up might give those specific bodies additional protections. There is nothing, so far as I can see, in the very big, fat legislation relating to NAMA or Anglo-Irish Bank that goes one way or the other on this. There was no thought given to the possibility of this being FOIable, which I suppose answers my question, will the minister do it? No, because when he could have done, he didn't. But there are other pieces of legislation that might also prevent the information coming out. It might be a state secret and therefore covered by the Official Secrets Act or the Offences Against the State Act. You can't forget data protection, because data protection provides additional protections for information about individuals, and expanding constitutional privacy rights will start to trench upon all of this legislation as the Supreme Court expands on the constitutional protection of privacy. I was interested in a point that Sean made about the salary of the head of the NTMA being ultimately made available under FOI from the Department of Finance. So, as Gavin has pointed out, there are lots of indirect ways into getting the information. Even if the minister doesn't make the banks available or amenable to FOI, even if he does and there are exemptions that might be applied, you might be able to get around it. You might be able to get FOI from an adjacent body or from the department that oversees all of these things. So in the same way as the salary of the head of the NTMA was available from the Department of Finance, a lot of the information about the financial crisis, even if not directly available from one of the banks or from NAMA, might be available via the department, which is a body subject to the FOI legislation. I think what my little set of hypotheticals has demonstrated is that the law relating to FOI is a mess. It would be a lot easier if we didn't need it, if we had a culture of disclosure. It would be an awful lot easier if the legislation could be driven by a strong constitutional right of access to information in the public domain, or public information that ought to be available in the public domain, but we don't have that yet. The references to the Constitution in the various pieces of legislation and in the various cases that have come to the High Court and the Supreme Court make no mention of this kind of argument. From an international perspective, our Act isn't a particularly strong one. And the inability of the FOI legislation to apply in the kind of financial context that we have had for the last 2 years demonstrates that, I think, quite clearly. But just to locate where we are in some international principles, I had a look at a document published by UNESCO on freedom of information, a comparative survey, and they set out 9 principles. Can't quite work out why they didn't manufacture a 10th just to make the list nice and simple, but they didn't. They only have 9. And I think we do very badly on most of them. The guiding principle of an effective freedom of information regime, UNESCO tells us, is the principle of maximum disclosure. And I invite Gavin to tell us whether or not we live up to the principle of maximum disclosure. I think not. The UNESCO says that public bodies should be under an obligation to publish key information. No, they're not. They're under an obligation under the Act to make some information available, quite a small limited amount, and as for the rest, people like Gavin have to go digging. Public bodies must actively promote open government. Well, apart from the Office of the Information Commissioner, I'm not sure that there are many public bodies actively promoting open government. There's quite a broad range of civic society doing so, Transparency International being a very good example, but the government doesn't actively promote it. Exemptions, we are told, should be clearly and narrowly drawn and subject to strict tests. The High Court has said this, but the departments aren't listening. The departments try to interpret the Act very broadly. The Office of the Information Commissioner hits them over the head and says, you can't do that. Then they appeal to the High Court, and the High Court says you can't do that. But the culture is moving very, very slowly. Requests for information should be processed rapidly and fairly, and an independent review of any refusals should be available. There are time limits in the Act which are intended to ensure that it does happen rapidly. If the department or if the FOI request isn't dealt with quickly or within the time limit, that automatically triggers an internal right of review. But I don't get the impression that the Act works very effectively, subject again to what Gavin and Sean might say.